going to do is we're going to start really, really drilling down. Because like you said, evidence and the hearsay rule, it's massive, the whole area. So we've just talked about some of the general concepts to try and letting people get their heads wrapped around what hearsay is.
Right.
Now we're going to start drilling down, and specifically what we're going to be talking about is one specific kind of hearsay evidence that comes up all the time in family law cases.
Yes, please.
Okay, and we're talking about one type particularly, and that is children's statements.
Yes.
And how to use things that kids have said when it's being called as evidence in a family law case.
Yes.
And that's and again, so to narrow it down, what we're going to be specifically talking about from here on in is hearsay that is specifically somebody either testifying verbally in court or swearing in an affidavit that's being used at a trial.
Right.
It says, I am a parent of this child, and I want the court to believe that what this child told me, what I'm going to tell you now, is true. So that's hearsay, because I'm reporting to the court what the child told me. And that is hearsay. And the question is, can those types of statements be admitted to court or not? And that's why this case, AM versus DM, is so interesting, because the judge actually goes through generally how the rules of hearsay are used in a family court proceeding. But specifically, this case deals with hearsay that is comments or statements made by children to a parent or another adult. It could be like, or it's someone, one of them is a teacher, one of them is a therapist, one of them is actually somebody that was appointed or hired to interview the child, to get information from the child. So it's just a very interesting statement. There are all kinds of other types of hearsay that can arise in a case. Like I could testify about something that the other party said to me. That would be hearsay as well, if I'm reporting to the court what the other person said, and that's between adults. So we're really, really focusing on a parent trying to use a statement that was made by their child to either them or somebody else in the past, outside of the court proceeding and everything else, and whether in fact those statements should be admissible. Okay. So to set the ground rules, the situation we're talking about is a child tells parent A about something that happened or something that was said when the child was with parent B. Parent A wants to tell the judge at trial, or either orally or by filing an affidavit, saying what the child told parent A about what had happened when the child was with parent B and parent A wasn't there. And the whole point of this case and what it turns on is, should parent A be allowed to do this? So this is basically what the judge in this case, and it was Justice Mills, who's a great judge, what she actually said is she did a really, really good summary of what happens with the hearsay rule when you're dealing with family law cases. The first thing that she said is that generally you can introduce hearsay evidence in affidavits when you're arguing a temporary motion. Like because when you're arguing a motion, you're not getting up and you're not testifying under oath. You're asking the judge to make a decision on the basis of affidavits and other materials that are filed between the parties. And although it's acknowledged that it is still hearsay, it might be contained in an affidavit, there are concerns and issues about reliability and whether in fact it should be introduced or not. But when you're arguing an interim motion, that's what you've got is the affidavits. So the rules of hearsay have been relaxed in family law matters. If you're going to use hearsay in an affidavit, the generally accepted rule is you can use it in procedural interim motions, but you cannot use it at a trial. And what's happened in this case is that both parents tried to file tons of affidavits that are just full of statements that they're saying, well, my child told me this, my child told me that, my child said this is what the other parent said. And what the judge basically said, this is not kosher. This is not cool. Trials should be done with a minimum of information being provided by hearsay that is contained in affidavits. And there are still problems with hearsay, even if it's being given orally, not like written out in an affidavit, but it's a really problematical in affidavits. So generally, though, trials then should not be letting people use affidavits that contain hearsay. But we know that the rules of hearsay are relaxed when you're talking about family law matters. And the judge goes through some of the history about why this happens is because you have to be flexible when you're considering the best interests of the children. And you have to ensure that all the relevant information, and which includes information about the character of the parents, the party's lifestyle or the past conduct, And you need to get this information before the court when you're trying to assess what parenting plan is in the children's best interest. So the rules of evidence are relaxed a little bit. And to avoid compelling children to give evidence in family law trials, because that is not good. Nobody ever wants kids to have to get up on the stand and talk about their parents and get cross-examined. Hearsay evidence of children can be admissible as one of those principled exceptions that we talked about. And that hearsay evidence from children can be admitted if the evidence is, one, necessary, and two, if it's reliable. So necessity is satisfied if, in the circumstances, it would not be appropriate to call the child as a witness to give evidence, and there's no other way to get that evidence. In that case, that hearsay evidence becomes necessary. The reliability test is met if the evidence is not objected to by the other side, i.e. if the other side agrees that saying, yep, this can go in because we're acknowledging that what the child said is probably true. If the child has repeated the same statement to more than one person in the past, because then you can still have those people called and they can testify to that. So in that case, rather than having to call all these other people, we know they said it to more than one person, that's a principled exception to the hearsay rule. Or the third big one where you see it is where the statement has been made to a person who has a demonstrated skill in interviewing children. And that's why quite often, and the latest thing that's come out are the voice of the child reports, where either the court will order or the parties will agree to have a trained professional who, in dealing with interviewing children, to go and talk to the children, to talk to people that are very important to the children and involved in the children's life. And that interviewer will then prepare a report, which sets out what the child told them, what the child's position is, what other people have to say about what they've seen with respect to the children. And then it is that person that gets up and testifies in court. And that's the prime definition of hearsay. I, as the professional, are coming in and saying, this child said this to me. And that's one of the principled exceptions, is saying, because we don't want to make kids get up and testify, when you have a trained professional who knows how to interview children and does it properly and does it well, who's unbiased, who's experienced, who knows what they're doing, yes, as an exception to the hearsay rule, we will allow that person to come into court to testify about what the child said to that person. And it could be something as much as saying, I don't want to live with my mother. I don't want to see my father and stay at his place overnight. All those kind of things are, the professional is testifying to that. It's hearsay because they're saying to the court what the child said to them. But in this circumstance, it's one of the principled exceptions, because this is somebody who is trained to do this and they're asked to do it because you don't want to have the child come to have to court and have to testify on their own behalf.
Right. Sounds good. Okay.
Okay. So.